As I'm going through the state's records, I know it doesn't match up with the records that the family gave me previously. So I get them, I lay them together, and I look at them. And what I have, I got a little wind, but what I have is a document. Stated Tallahassee Memorial Health Center. It's got a cross up in the upper left-hand corner. Now these two documents, this from the state, this from the family, they appear like they're the same document. Although the document that the press received from the state does not have information regarding the prescription given to the victim for pain. It does not include a circle which says follow up with the family. It does not include clinical impression, which says sexual assault, muscle strain, lumbar, muscle strain, lower extremities. All of those notations are absent from the medical document, the identical medical document, except for the omissions. It's the same document. It doesn't bear a signature. This one bears a signature. So what I have here are two different documents. Let me rephrase that. What I have here is two documents that appear to be the same document, one of which appears to have significant omissions specifically related to the injuries suffered by the victim in this case. And then I have another document which itemizes and specifies the victim suffered by the victim in this case, the injuries suffered by the victim in this case. There is no reason, ladies and gentlemen, why the state would redact the injuries sustained by the victim, the name of the person who did the report, and the drugs that were issued to her for pain. There's no reason this would be redacted. In fact, I specifically requested a copy of unredacted documents from the state attorney's office to ensure that we didn't make any errors. In my copy of unredacted documents, I have this same document that was sent to the press. So we perceive that as a problem that warrants further investigation. When I saw that, I became immediately concerned. Secondarily, there's another page that the press never received from the medical records, which the family received, which is another page, Tallahassee Memorial Healthcare Center, with the cross in the upper left-hand corner, with a diagram of muscle spasms that the victim had in the back, injuries to her foot, all these circles. Let's see. You didn't get this, ladies and gentlemen, but it's in your packet, which I'll be handing out later. She puts the physician or the rape evaluator, joint pain, neck pain, back pain, numbness, weakness, fever, chills, fatigue. Let's see. Pain in lower back, pain in legs, feels like muscles are sore. Additionally, there's documents also in the family's medical records that show a negative pregnancy test, which had to be taken, of course, in a rape case. Sexual assault discharge instructions, which also suggests it comports with the diagnosis of the clinician that this was in fact a sexual assault, and includes some documents that reflect the medications that were prescribed to the victim, specifically Valium, because she was nervous and a little hysterical earlier, and naproxen for soreness. So none of those records were released to the press. Additionally, a sexual battery claim form, Office of the Attorney General, not released to the press. Now, the other documents we have were released to the press. But I believe the state's medical records consisted of 4 pages, while ours consist of 11. After I looked at that, I was that much more concerned about the veracity and accuracy of the blood tests and the urine tests. I did not see these medical records until after receiving the documents and after Mr. Meggs closed his investigation. But I did articulate to Mr. Meggs my concerns. So when Mr. Meggs did his investigation, he came across a second set of DNA. A second set of DNA that the victim, during a meeting with the state attorney's office on or about the 21st of November, she specifically told the state she believed that that second set of DNA was from a consensual sexual encounter she had with a gentleman she was dating. The gentleman was not in the state at the time of December 7th, 2007. He hadn't been in the state for a little while. The gentleman lives in Ohio. During that conversation, she said, I do believe that's from a prior sexual encounter with that gentleman. Now, ladies and gentlemen, there's a rape shield statute in the state of Florida. And that rape shield statute specifically states that if a rape victim has prior consensual sex with their boyfriend, that is not admissible in a court of law. Okay? Because otherwise, the sexual history of every rape victim would be brought in front of the court for everybody to see, to embarrass, humiliate, and demean the rape victim. And that is why the law is in place. So these things do not happen. So what occurred in this case was the state found the second set of DNA. They brought it to my attention on the 11th of November, the 18th of November, when I went up to Tallahassee and had a meeting with Mr. Meggs. During that meeting, I specifically told Mr. Meggs that we would cooperate, we would do anything he needed us to do in this case to assist him to facilitate his investigation. During that time, he indicated he had two sets of DNA. I wasn't aware of it. They met with my client, not Mr. Meggs. He never met with my client, but his assistants met with my client on the 21st of November. During that meeting, they asked her, is that from a consensual encounter? She said, I do believe it is. At that time, they said, would you kindly give us his name? She said, I'd rather keep the gentleman I was dating before this incident out of the middle of my rape investigation. They dropped it because they understood, I presume they understood it's not admissible anyway. Thereafter, I thought that issue was over. They made a comment to her, is he the gentleman from Ohio? And she said, he's a gentleman from Ohio. She thought they knew who he was. No further comments, no further communications from the state on that. The following week, I called Mr. Meggs again to address the issue of the blood and the urine, the veracity of that. During that conversation, Mr. Meggs was harping and continuing to focus on that second set of DNA. And I was quite surprised. And I asked Mr. Meggs why he was focusing on that, because it's not admissible in a court of law, because it's probably related to a prior sexual consent encounter. And he said he had to rule it out, he had to rule it out, he had to rule it out. I said, okay, well, I'll tell you what, I'll do whatever you need. Do you want me to contact the guy in Ohio and get you the DNA? Get you a buccal swab, excuse me. And he said, we already have the guy. If you could assist us to get him to cooperate, that'd be great. I said, I can definitely do that. So I had no idea, all this time he's focusing his time and his energies tracking this gentleman, this boyfriend of the rape victim down, using resources to do that, rather than just calling me and saying, hey Pat, can you get the guy in? We want to take a buccal swab. I would have done that in a heartbeat. So when I'm talking to him about the blood, he mentions it. I get off the phone, I call the victim, and I tell the victim, could you please go contact the gentleman who you were dating prior to this incident and have him contact the state attorney's office. She immediately left, went to his house, left a note on his door, and by the time he called me, the state had already contacted him and taken his buccal swab, which turned out to be a match on the DNA. That's a prior consensual sexual encounter with the victim, which I shouldn't even have to be addressing right now, but I am having to address it because the state brought it up. It is contrary to the law that this is utilized to impeach the character of the witness, the victim, and to demean the victim. And specifically, during Mr. Jansen's press conference, which I watched briefly, there were references to whether or not this victim had sex with two guys in one night. This is what we're dealing with on the side of the victim. Accusations, suggestions that she's running around having sex with two guys in the same night and it's all consensual. Ladies and gentlemen, I'm here to tell you that the encounter, which I shouldn't even have to address, but I'm going to, obviously the circumstances require it, that sample, that DNA was from a time well in advance of this attack, had nothing to do with this attack, and is not admissible in a court of law. And yet, that was the focus of the state attorney's investigation in this case. Again, an investigation into a rape victim, not an investigation into a rape suspect. The state attorney's office, when they took this case over on or about the 12th or 13th of November, had an opportunity to go back, and I apologize, I'm going to have to put my sunglasses on. They had an opportunity to go back and check this investigation out from the beginning to the end and notice that the bulk of the investigation was into the rape victim. They had an opportunity to get a search warrant into the phone records of Mr. Winston and the text messages of Mr. Winston. The state attorney had an opportunity to get search warrants into the phone and text and Facebook messages of Accuser and the other guy. Can't think of his name. They did not do Darby. Thank you. They did not do that. When I read this report, I contacted Mr. Meggs on the phone and said, Mr. Meggs, what I'm looking at here is an investigation of a rape victim, not a rape suspect. I specifically addressed that with him. I articulated my concern about the magnitude of the investigation into the victim. He told me, and specifically the phone records, and he told me he could not get the phone records. I asked him, why, sir, did you not get a search warrant for the phone records of Winston, Darby, and Accuser? And his response to me was, that's a good point. He contacted me Wednesday, called me back, and he said, the reason we can't get those records is because they're no longer available. Well, I did some research, and it seems to me that Verizon records are available for a year from the time that they were made. They had the case under a year. It's been a year now. It's past December 7th, so those records from Verizon may be gone. But Sprint and AT&T, as I understand it, keep records up to 5 years. Now, that bears additional investigation, but I do not buy that the state could not obtain those records. They didn't try. If they had tried to obtain those records and came to me and said, we tried, Ms. Carroll, they're no longer available, here's a response from the providers, I'd have been satisfied. They didn't even make that effort. All they did was continue to investigate the victim. In light of the medical records, the missing data on the medical records that we cannot account for, this family at this time has absolutely no confidence in those blood and urine tests. Let's talk about Angulo's investigation for a moment. The problems with Angulo's investigation are so significant and so multiple that if I stood here and tried to go through them point by point, we'd be here all day. So I added them in your packet on the back as bullet points. But I want to highlight some, what I consider to be quite significant facts. And that is this. I've been working with law enforcement. I'm a prior assistant state attorney. I'm not a law enforcement officer. However, it is my understanding that law enforcement officers historically and typically, and as a matter of protocol, when they do an investigation, they document the case. They supplement their report. So what they do is they make a report. For example, in this case, when Officer Fallis from Tallahassee PD reported to the hospital, he interviewed the victim, he wrote a police report. That's standard operational procedure. You write a police report. Angulo took the case over. He interviewed he met the victim at the hospital on the morning of December 7th. He then interviewed her on the afternoon of December 7th, using a video camera. He never recorded his encounter with her, let me rephrase, prior to February 11th, 2013. He meets with her December 7th at the hospital. He doesn't supplement Fallis's report. He takes a video interview of her of the victim on the afternoon of December 7th, after, by the way, she's been throwing up and sick and hasn't had any sleep since the night before, neither here nor there. He takes a video interview of her on the 7th. He then calls her on the phone on December 17th, and I have in your records, in your packet, a phone record that is just one thing that's not redacted, and that's the phone record where Detective Angulo contacted the victim on December 17th and had an 8-minute call. During that 8-minute call, the victim again was required to relate what occurred to her on the early morning of December 7th to Angulo over the phone. That was the 4th interview she had. He doesn't record that discussion anywhere. That discussion isn't even in the report he provided on February 11th, 2013. It's not referenced. Then he interviews on the phone, he calls up Bria Henry, the outcry witness, on the 18th of December. He doesn't record his interview of the outcry witness on December 18th. Then the victim calls him on the 10th, leaves him a message, "I think I know who the guy is." He calls her back. They have a conversation on January 11th. She identifies the suspect. He doesn't record that in any police report. It's still nowhere of record. She identifies the suspect as Jameis Winston. On January 13th, Mr. Angulo drove by Mr. Winston's house and looked at the apartment building and looked at the outside of it. And he confirmed in a phone call to me on January 13th that the description that the victim gave him of Mr. Winston's apartment matched exactly the location where Mr. Winston was residing. So probable cause is building, is present, is there. You have a rape kit, you have physical evidence, you have blood in the underwear, you have semen, you have marks and bruises, you have a sprained back, some scrapes on the feet, so you have injuries, you have identification, you have an immediate report, and he doesn't issue probable cause to get a search warrant for Mr. Winston's DNA. Instead, he issues a search warrant into the victim's phone records. He doesn't record his conversation with Mr. Winston, contemporaneous, which was brief. Mr. Winston refused to talk. He then spoke to Mr. Winston's attorney. He didn't document his conversation with Mr. Winston's attorney in any police report. Then he closes the case on or about February 11th, stating that's when he writes his report. That's when he goes back more than 60 days and compiles a police report of all his actions in this case, and he writes it down. If you look at the police report, ladies and gentlemen, of February 7th, 2013, that Angulo wrote, you will see inconsistencies in there, repetitions in there. You look at it and make your own decision, but it doesn't read like a typical police report. At the top of one of the pages it says she described the perpetrator or the suspect as being 6'2". Later in his report, further down, he puts she identified the suspect as being 5'7" to 5'11". It's all on the same page of that police report. Take a look at it. It's quite interesting. However, it's never released to the press that in that police report she identified him as being 6'2". I can't account for why Mr. Angulo's report of February 7th, 2013 has two completely different physical descriptions. He never stated that the victim contradicted her physical descriptions. And he also has some other contradictory statements in that February 11th police report. Specifically, at the top of the police report, he puts she couldn't identify or describe the apartment. In the second half of the police report, it says she described the apartment, and she describes it specifically as much as she could. So that's a very suspect situation. I don't understand it. It bears looking into. But Mr. Angulo didn't record any of the investigation prior to the date he closed the investigation. Additionally, he then received FDLE reports in March of 2013 in this case. he failed to notate or supplement a police report. Those are not notated anywhere until they're notated in the police report filed by Tallahassee PD in November of this year, like months and months and months later. So he receives an FDLE report in March of 2013, doesn't document it. He receives an FDLE report again, second one, in August of 2013. So Mr. Angulo wasn't investigating this report. FDLE was on the job all the way into August of 2013. Provided a report to him, and in that report, in August of 2013, FDLE specifically stated they found foreign DNA, and that if Investigator Angulo had identified a suspect, that he should immediately send a buccal swab to FDLE for comparison. He received that correspondence from FDLE in August of 2013, and he failed to do that. He did not conduct an investigation, ladies and gentlemen. He did not record his investigation until he closed it, and whatever you call it, I guess you can call it an investigation, I would not. That is, and the nature of the evidence he failed to preserve that's outlined in the packet is staggering. No investigation was conducted to speak of into the suspect in this case. I specifically asked Angulo during our conversation on the 15th to go get Winston's DNA, and he stated to me, I'm not going to do that. I don't want this to become public. And then he went and contacted Winston, completely contradicting what he told me he was going to do. I specifically requested the DNA. I specifically told him I disagreed with his decision not to go get that DNA, and while he wasn't getting the DNA, he was getting a search warrant against my client. Search warrants are inherently adversarial, ladies and gentlemen. I would have gladly signed a release for her medical records or anything he needed in this case. As to the Tallahassee Police Department, if you look at the police report that Officer Harris completed and that was submitted to the press from the State Attorney's Office, there are no signatures, there is no date, and there's no reviewing officer. That is customary and standard procedure, to have a date, a signature, and a reviewing officer. They're missing on that police report. I checked the unredacted statements. It's also not in the unredacted statements, ladies and gentlemen. So the totality of the circumstances that we face here, in light of our review of this investigation, leaves us no other choice but to call upon the Attorney General of the state of Florida to conduct an independent investigation into this case and the Tallahassee Police Department. Because if victims are subjected on an ongoing basis to what this victim has been subjected to, there's a serious problem in the state of Florida, certainly in the Tallahassee area. And I will at this time open up the floor to questions.
Ms. Carroll, do you believe that TPD intentionally set about going at this investigation with the idea of clearing an FSU football player? Is that your opinion? How would you characterize an investigation?
Sir, I can't tell you what their intentions were. Those are internal and subjective. I can tell you by looking at all of the documents that I've received, that's a conclusion one could reasonably draw, yes. But I don't know what their intentions were, and I wouldn't opine on that.
How would you characterize an investigation overall? Just characterize it.
I would characterize the investigation overall as an investigation into a rape victim as opposed to a rape suspect. That's how I would characterize the investigation.
Do you think this was a cover-up to protect a potential Heisman Trophy winning quarterback by either the police department, the state attorney's office, or the school?
The Heisman issue, to me, that was not an issue that was present when this case was first reported, sir. I'm going to address your question. Do you want me to?
Cover-up? Yes or no? Is this a cover-up to protect a star athlete at
Well,
FSU?
okay, if I may address your question. The phrase of your question was this a cover-up to protect the Heisman Trophy candidate? I'm addressing that, sir. Okay? at the time that the behavior started by Angulo, I don't believe the gentleman was a Heisman Trophy candidate, okay? So it appears to me to be a complete failure of an investigation of a rape case. Do I believe that that complete failure of an investigation of a rape case was related to the fact that this gentleman was on the football team? I do. Yes. Whether or not, because at the time that she reported this rape and that this occurred, I don't know how prominent the gentleman was. She didn't know who he was. The only way she knew who he was she was sitting in class in January and he walked in and she saw him and sat there quietly and waited for roll to be taken so she could listen to his name.
Sure.
And she did that.
During
So
the
go ahead.
During the state attorney's investigation by Mr. Meggs, he was known to be a potential
Yes, sir.
Heisman. He was a star quarterback on a national team. At that point, do you think the attorney's office, which you said it appears has provided either not the entire medical report or altered medical reports, was it a cover-up by the state attorneys then to protect a star potential Heisman athlete?
I would not make that statement, no, sir.
Ms. Carroll, is it possible?
Hold on, one at a time, please. And if you guys could kindly identify who you are briefly before you ask the question. You asked the question, yes, sir.
I'm Jeff Burley with the Tallahassee Democrat.
Yes, sir.
Have you or your client considered any civil litigation in this matter at all, or simply calling for court?
At this time, we are not looking at civil litigation at this time, sir. When we cooperated with Tallahassee Police Department, as I said, I sent him a letter telling him to keep me apprised of the investigation. So we cooperated with Tallahassee PD, and when this hit the press and the state attorney got involved, we cooperated with the state attorney's office, and we just received this report on Monday. I did, reviewed it. We're just dealing with this right now. So it's premature to say that, sir.
Ms. Carroll,
Yes, sir.
Andy Alcock, WCTV Tallahassee. I wanted to ask you about the redacted medical records. Is it possible that the police and the state attorney didn't give us those records out of HIPAA concerns, possibly?
No, sir. The documentation of the injuries in a rape case are a pertinent part of the investigation. You have other pages that the state released. Frankly, they're a little graphic, but you have other medical records that the state released that were clearly documenting generalized vaginal tearing, bruising, that sort of thing. So that was released. Certain records were released that were constituted medical records. They were redacted under the Freedom of Information Act. I believe they gave these to you. I mean, I'm not a HIPAA expert. However, as I said, I specifically requested from the state attorney's office unredacted statements, so that the unredacted packet, so that I could ensure that I was checking what was redacted from what was not redacted. Do you see what I mean? The original document. And in my unredacted packet, I have the same document you have. Ergo, it's not redacted. So, additionally, the redactions are very noticeable in the packet. Throughout the packet, the redactions were black ink, everything's redacted with black. This is not redacted. They're missing entirely. The data is entirely missing. So a gentleman, made a comment about falsified records or altered records. I don't know who would have done this. I have no idea, sir. I'm not standing here saying the Tallahassee Police Department altered records or that the state attorney's office altered records. In fact, I would suspect that the state attorney's office received the same records they released. So that begs the question, as to these medical records, who or how did this material end up missing from the medical records? That's a question I'm looking forward to getting an answer to. and addressing further. I just identified this issue this week, but it's a very significant issue. Now I'm going to ask, does anybody, you're great, does anybody else have any other questions?
Ma'am, over here.
Yes, sir.
Eric Waxter with ABC Tampa. Your client saw Mr. Meggs say the case was dropped last week. Tomorrow he might win the Heisman Trophy. What's her mindset right now? What does she want to see happen?
She basically is trying to get through her final exams right now through special accommodations that have been made for her by the college, by the university. So that's what she's doing right now. She's not focusing on the Heisman. I'm not focusing on the Heisman. There's been some comments about the timing of this press release. When Mr. Meggs suggesting that we're doing it because of something going on tomorrow with the Heisman. When Mr. Meggs gave his press release last Thursday, I was unable to review those documents or follow up with the press release earlier because I was out of the state of Florida until Sunday afternoon. And I came back Sunday afternoon and I did not have the records from the state attorney's office. I contacted Mr. Meggs Thursday morning when I understood he was, actually in fairness to Mr. Meggs, he called me Wednesday. I was on a plane to tell me about the press conference he was given Thursday. I called him back Thursday morning. We had a conversation about his press conference. During that conversation, I specifically requested that he forward to me in advance the redacted documents and the unredacted documents so that I could review them upon my return to the state of Florida, which would be on Sunday. When I returned on Sunday, I had no documents. When I spoke to Mr. Meggs on Monday morning saying, where are my documents? I need to review these documents. He indicated they didn't go through on the email that he sent them to me. So he overnighted he faxed, excuse me. At that time, I asked that he faxed the unredacted documents and he mailed the redacted documents to me, sir. So I needed time upon returning to the state of Florida to review the packet, to formulate an analysis, and to give the press ample time to collect themselves to be here today. Yes, sir.
Matt Baker, Tampa Bay Times. Why did communication break down with you all and Tallahassee Police and when?
That's an excellent question. As I mentioned, I sent the letter, which is in your packet, to Angulo on the 11th. He contacted me, I believe, on the 13th, or I contacted him, regarding going by Winston's house and verifying it matched the victim's ID. I then called him again on the 15th of January, and after the 15th of January, Mr. Angulo would not return my calls. Instead, Mr. Angulo had the victim's advocate, Fornisha Brown, return my calls. I had contact with the state attorneys, with the Tallahassee PD. I called them several times and specifically requested the toxicology reports. I could not understand why I did not have the results of the toxicology report as of the 15th of January. I didn't think it would take that long. During the conversations with Fornisha Brown, I was asking, when were those toxicology reports sent down? And she said they were sent down in December. And I said, when in December? This occurred on the 7th of December. When were those toxicology reports sent down? We need to know. We need to verify that she was drugged, because that's the only explanation as to what she experienced that day. We need verification of that. I focused on that unilaterally to the exclusion of all else with Mr. Angulo. He never, and Fornisha Brown then said, oh, they were sent down the end of December. And then when I received this packet, I see the results were not even, the toxicology samples were not even sent until the 17th of January. I contacted them, I believe, in February. I definitely contacted them in March regarding these toxicology reports. So while I'm contacting them in March, his case is closed. I'm talking to Fornisha Brown. When he called me on April 4th and said, we got the tox results, he never told me this case was closed. In fact, Mr. Angulo never gave me the courtesy of telling me that he had contacted Mr. Winston in this case. So in terms of the information dropping, as soon as Angulo contacted me after my relentless attempts to get records from him as to toxicology results, when he called me on the 4th of April and he told me that the urine came back with no drugs in it, that they did not test the blood for drugs, they only test the blood for alcohol. Quite frankly, at that time, I was very concerned about what I was dealing with. I had a gentleman who was refusing to take DNA from a suspect, and I had a very suspect urine result. At that time, I talked to the family and said, you know what, family, victim, you do not want to go and challenge an entire police department in this case. There's something very fishy going on here, and we don't have the time, and we don't have the resources, nor do we have the stomach to go and challenge the entire Tallahassee Police Department. So we did not pursue any further conversations with Mr. Angulo at that time, out of basically fear and concern for what we were encountering, out of our overall concern as to what was happening in the case or not happening in the case. Now, when the report came in August on the rape kit, now that's evidence coming in to the investigators' hands in August, stating that there was a foreign DNA present in her underwear. It was incumbent upon Mr. Angulo at that time to contact me and inform me of that. He failed to do that. He never said, do you want to stop, do you want to not prosecute? I mean, I'm sorry. He did suggest that we don't prosecute. What he never did was say, do you want to close this case down with certainty? I said, what we need to do here, Mr. Angulo, and this was on the 15th of January, I said, the victim she's already been interviewed 5 times. She needs to go to class. This happened right before exams in December. It absolutely affected her finalizing her exams in December. So I said, why don't I be the contact? She can go to school. You keep me up to date on the case. And specifically in my letter, I said, I'm awaiting the results. I want the results of the DNA, the toxicology, and the blood. I kept referring to the blood. So when he gets the results in August, he never contacts me. So that's, like I said, that was incumbent upon him at that time to contact me and tell me of additional evidence in the case, and he failed to do that. We did not do anything else on this case. We're not investigating the case. My client is a victim in this case. It's not incumbent upon her to conduct the investigation. We made it abundantly clear to Mr. Angulo that she needed to go back to classes, she needed to get some counseling, and we needed to let him conduct his investigation before we sat down with him and had input into whether or not he was going to prosecute. It never occurred.
Scott Withers, ABC News.
Yes, sir.
A quick question for you regarding Mr. Megg's investigation.
Yes, sir.
During his press conference last week, and also in the documents that have been released, and now videos that have been released, there were 2 eyewitnesses that supported Mr. Winston's side of the story. That your client was an active partner, it was consensual, and that she was at some point in time afterwards laughing, joking, and in a friendly manner on the way out of the apartment.
Right.
How do you counter those 2 eyewitness reports? Now, granted, they were taken in November. What is your response to the eyewitness reports? Because it appears Mr. Megg used those in his decision not to make the charges last week.
Yes, sir. I concur with your analysis that Mr. Meggs relied heavily on those 2 statements in making the decision not to proceed. Those 2 statements were made by football teammates of Mr. Winston, one of whom was his roommate, one of whom was upstairs. In fact, the gentleman, Mr. Casher, who made one of those reports, or affidavits, which I think might have been facilitated by Mr. Jansen, I'm not sure, in terms of the investigator who took them. I don't mean he prompted the witness, I'm just saying I think the investigator might have been retained by Mr. Jansen, who is Winston's attorney. But so we have the affidavit that was issued or executed, I think, on or about the 13th of November by Mr. Casher. And Mr. Casher makes inconsistent statements. Mr. Casher stated during a video interview that was released this week that he videotaped Mr. Winston and the victim, or in his case, you know, the willing participant. He's asserting that he videotaped them having sex when they weren't aware of it. That's a crime, ladies and gentlemen, to videotape somebody when they're not aware of it. It's called video voyeurism, and it's in the Florida statutes. So the gentleman, while he's being interviewed by the state attorney's office, admits to the commission of a crime, and then he says he took the video and he deleted it. That's a destruction of evidence situation. So you've got a video of a crime, an admission to a video of a crime, an admission to destruction of evidence in the middle of an investigation, a videotaped interview, if I may, in the middle of a videotaped interview of Mr. Casher. And the state doesn't do anything. They don't take any action. They don't even perhaps recognize what's going on. But if he wants to rely upon somebody who's got contradictory statements. One gentleman said she was sitting on the bed giving him oral sex. The other gentleman, well, I use the word gentleman. One man said she was sitting on the bed providing oral sex. The other man said she was on her knees providing oral sex. They're both his teammates. They both walked in one of them certainly walked in during the commission of a crime based on the statements of the victim. She specifically stated repeatedly, while she was being raped, the man with the dregs walked in the room and Winston said, "Get out." This is a person who was a prospective witness to a crime, a sexual battery, who failed to report it. Failing to report the commission of a sexual battery is also illegal. It's also a crime. So the people who he is relying upon are people who are theoretically committing crimes and admitting to it. So that's a problem. So additionally, if you look at those videos, and I encourage you to do that, look at the videos online of those men. Look at the video online of Jenna Weisberg, who is the outcry witness, the second outcry witness. And you make the evaluation as to credibility. And if it were me, sir, based on those statements made by Mr. Casher and Mr. Darby, between the written affidavits and the statements, I would have very little difficulty cross-examining them in a court of law and impeaching their credibility. I don't think that would be very difficult given their conflicting statements. So there is no way that it was proper, in my opinion, for the state to rely upon those two witnesses in making a decision as to charging in this case. They are completely biased witnesses. And additionally, yes, to your point, the fact that those statements were not taken early in the case, the fact that they were only taken after the press got word of this situation up there in Tallahassee and started digging, only then did the state attorney's office and did Mr. Jansen's investigator start filling in the holes, trying to do some patchwork.
So just to clarify, you believe that the two witness statements that were videotaped and also given to the police by the roommate and also by a neighbor were fabricated to protect Mr. Winston?
I believe, as the victim's attorney, that those statements are patently false. Soup to nuts. Next.
Ms. Carroll,
Yes, ma'am.
Juliet Booker with the New York Times.
Yes,
I
ma'am.
was wondering at what point you felt like, or you realized something was fishy was going on with the case, and can you describe exactly what you feel you're up against?
Yes. The first day I thought I was up against something fishy was when the first conversation I had with Angulo on the 11th of January, when he said to me, "Your client might want to think long and hard before she proceeds with this case because she's going to be raked over the coals and her life is going to be made miserable." That's what he said to me. I was stunned when he said that to me. That is exactly why I followed up with the letter on January 11th. I don't typically follow up every conversation I have with somebody on the phone with a letter. I had grave concerns about him that day because I specifically asked him to go get Winston's DNA on January 11th, and he refused to do it. That was my first huge red flag. Well, his statement was my first huge red flag. The second huge red flag was his outright refusal to go collect DNA of an identified rape suspect.
And what do you feel you're What
we're up against? Does the thing speak for itself? I think I might have already addressed that. We felt then that we were up against a situation with the Tallahassee Police Department. I want to be careful with choosing my words here, but it was very obvious as this progressed that we didn't feel we were going to get a proper investigation. We didn't feel we were going to get justice, and we had to make some decisions, and we made those decisions, which is to just, what a lot of rape victims do, is just quiet down, let the guy do his investigation, and see what happens. Yes, we felt like we were up against. Yes, sir.
Ms. Carol, Rod McDowell, independent writer. So which story, so are you suggesting today that your client was drugged and then assaulted, or was she hit on the head like she said and then assaulted? Which one was it?
Let me address that. She didn't really say she was hit on the head. If you listen to Jenna Weisberg's video, she said she thinks she was hit on the back of the head because she woke up on the floor of an apartment. So what occurred, in my opinion, sir, is that she was drugged at the bar because she has a recollection of the first half of the evening. She was being followed around by the little short guy, she and her friend, being followed around by the little short guy, and then she encountered a big black guy who gave her a shot. She didn't see the shot poured. She didn't know where the shot came. Foolishly, she took the shot. She drank the shot. After she drank the shot, her recollection becomes very sketchy. She doesn't even remember the text that she showed her friend that was subsequently not in her phone, which we can't understand how that happened, except somebody must have deleted it.
But she remembers the size of his bed and
well,
the color of his sheets.
Let me address that, yes. So after she took the shot, her memory is intermittent. She finds herself in a cab. She finds herself on the back of a floor in an apartment. She has fragmented memories. So yes, the fact that she remembers the bed and the sheets, she was on the sheets while she was being raped in her statement, sir. So that's a very traumatic, vivid situation. She doesn't remember how she got there. She doesn't remember how she got in the cab. She doesn't remember. She does remember being on the back of the scooter, but she doesn't remember getting onto the back of the scooter. So her memory is completely consistent with the memory of somebody who has been drugged. There's no reason, well, let's just strike that. Her memory is completely consistent with somebody who has been drugged. Her head, you inquired about. She was saying, my head hurts so bad, I think I got hit in the back of the head because I woke up on an apartment. She was trying to figure out what happened to her. So she's making statements, and interestingly, she's making statements to the police, to the state attorney, trying to say, this is my experience, this is what happened. So she's very forthcoming with the statements, not realizing that statements, those lapses in memory and that fragmented memory that she had because of whatever she was dosed with, I don't know, was going to be turned around and used against her to say she's not credible. Specifically, the hit on the back of the head. I see where there's a snapshot in here, a snapshot of a screen message from Bria Henry, which was the very first witness, outcry witness, and the victim, saying, I got hit in the back of the head at a party. The second outcry witness, Ms. Weisberg, says she said she thinks she got hit in the back of the head. She thought she got hit in the back of the head. Absolutely. At the time that this went on, she did not know what happened. She didn't say, oh, I think I was drugged last night. She could not figure out what happened. All she could do was report her experience, and that is what she did. And then subsequently, law enforcement and the state attorney's office used that to continually attack the victim instead of doing the obvious, which is, this sure looks like a drug situation. Let's test the blood and see if there's any drugs in the blood. Let's see if the blood was properly preserved for those 37 days between the time it was taken and it was somewhere at Tallahassee PD's evidence room as opposed to sent immediately to FDLE. I've never heard of such a thing.
Ms. Carroll, by your client's own admission, she said that she was at this bar. My understanding is she was underage.
Yes, sir.
And she drank possibly even excessively. How would you characterize her decision-making process to, first of all, go to the bar and have several drinks as an underage person?
You know, I'm not going to attack the character of the victim. I'm not going to have that discussion. I will certainly say that the fact that she's a college student in a bar, underage, and having cocktails is that she was ashamed of that, which is exactly why she did not want her parents contacted, because she was fearful that she did something wrong, that she drank underage. You have and you're asking this question, which is you have a rape victim who's vulnerable. She's vulnerable because she's underage, she's drinking in a bar, and she's not supposed to be. So because she has those vulnerabilities, she's a perfect target, you see. And so she gets dosed, she gets, according to her report, she gets raped, and you're asking me about her judgment as to going to the bar that night. I think her judgment of going to the bar that night with her friends is pretty consistent with the judgment of the other 500 people that were at the bar that night, and it's not uncommon for college students to do that. And I think that in a rape case, the judgment of the victim, the shortness of her skirt, the sexiness of her eyes should never, ever be addressed in a rape case, because then you're saying she asked for it. And I, sir, take offense to that. Yes, ma'am. Please refrain. Yes, ma'am. Yes, ma'am. I can't hear you, ma'am. Yes.
If the Attorney General's office decides not to pursue an investigation, what then?
We'll have a meeting and we'll figure out what the options are at that time. It's premature.
Have you asked them already, or are you going to?
No, ma'am, I have not asked them already.
Alan Cohen, NBC News.
Yes, sir.
You spent some time telling us that the victim now is preparing for finals and she's got some other arrangements that have been made. Can you go into detail? How is she doing, both physically, mentally? People don't get over this easily at all, and there's a long period involved here. Can you tell us how she's doing?
Well, sir, she's not doing well, but she's a strong girl. So she's doing as well as someone can be, given all the facts and circumstances. She's doing as well as she can. Did she have to remove herself from her sorority at Florida State University? Yes, she did. The impact on her of that, having to do that, it was pretty serious. She had a very close social network. She no longer has up there. She had to remove herself from the school that she loved. That's very devastating to her. So it goes on and on. She's in the middle of a media storm. It goes on and on. She's being attacked. Her character is being attacked. Her, whether or not she's promiscuous, which she's clearly not promiscuous. If you look through, the 152 pages of phone records. In fact, she states in here, I'm awkward around guys. So, her life's been turned upside down. So she's not doing well in that regard, but she is going to continue to try to heal.
Did she not find support at the university, including at her sorority? Is that why she left?
Ma'am, she left for safety reasons. Her sorority has been largely supportive. In fact, her sorority has been targeted. Their tires have been slashed at the sorority. There's been some threats made to her sorority sisters. The victim's advocate at Florida State University has been very supportive.
Quick follow-up.
Yes, sir.
You point out inaccuracies, inconsistencies in the report. And
which report, sir, are you referring to?
I believe both, the one from the DA and the one from the police. You're talking about Angulo's part of it. You're talking about a number of inconsistencies, inaccuracies. Can you also Can you share with us what all of this says? You also said that it appears more investigation of a rape victim as opposed to a rape suspect. Can you share with us a little more about what that means in terms of how the suspect, the ball player, was handled versus how the victim was handled in this? Can you elaborate a little more? Maybe
I don't know that
characterize that?
I don't know that I can elaborate anymore. I thought I've beat that kind of comment to death.
Characterize it a little, how one was handled versus the other?
Well, certainly. I mean, the resources employed by Angulo were directed at the victim. His resources employed were not directed at the suspect. He terminated an investigation without notifying the victim. I mean, I kind of beat that to death. In terms of the state attorney's office, I don't understand your question beyond that, sir.
Does it speak a little more to how ball players are handled? Getting a little more general picture here.
You know, I couldn't comment on how ball players in general are handled. This is a singular experience that I'm having dealing with Mr. Winston, Mr. Angulo, Mr. Meg, and this particular situation. I cannot say at FSU how other ball players are handled because I have no idea. I think it warrants checking into, of course, in light of this, but you know, I'm not focusing on football. Everything's not about football. Sometimes it's just about rape, and it's not about football, and it just so happens that the rape suspect is a football player. Sometimes that's just what you have, and I think that's what we have here.
Speaking about, you mentioned about Mr. Meg's focus on your client's boyfriend. By coincidence, perhaps, he happens to be an African-American collegiate football player. Do you think because of that, Mr. Meg's concluded that this was some type of preference of your client, and that's why he thought it might be consensual?
That would be one heck of a leap for Mr. Meggs to have made, and he's not a stupid man. He's not going to say, just because, just because she's dating a gentleman who's at Ohio State on the football team. I don't even know that the gentleman plays football. This is a gentleman whom she met in high school. So she doesn't run around chasing football players. She met this gentleman in high school. They formed a relationship in high school. And whether, you know, the fact that he's a black man has absolutely nothing to do with Mr. Winston being a black man. A black man is the guy who she identified as her rapist. She's not prejudicial, obviously, if she's dating a black man. So she's not running around trying to escalate the situation based on race. And then again, you suggest to me that she prefers black man football players. In fact, that's a good point. You didn't so much suggest it as the packet suggested it. So I apologize, because the packet suggested, and that's part of the problem. In this packet are 4 pages of the boyfriend. And one of the pages of the boyfriend is he's a football player. That's purposely, I mean, why in goodness creation would I have a picture that of the boyfriend and the fact that he's a football player encompassed in a packet and a rape case involving my client and Jameis Winston? Unless somebody is trying to plant a seed, the girl likes black football players. It's part of the problem that we see as a family, which is a targeting of the victim, an attack on the character of the victim. It's the victim's fault. She likes black football players. There's absolutely no evidentiary usefulness or any evidentiary basis to have a picture of this guy in there as a football player. It makes no sense. They have his driver's license, oh yes, and they have pictures, incidentally, of the licenses of the witnesses that support the victim. They have a picture of Marcus Jones, who has like a suspended license. They have a picture of his suspended license. They have a picture of Monique Kessler's license. They have a picture of somebody else's license. There's no photos in there of Winston's license. There's no photos in there of Casher's license. There's no photos in there of Darby's license. There's only photos in this packet of the investigation of the victim's witnesses. There's no photos of their investigation of the suspect's witnesses. And again, it's completely one-sided. It's so obvious that it was stunning. When I looked at it Monday, I spent all day reading it, and I just couldn't believe what I saw.
Does your client regret coming forward?
No.
Ma'am?
Why?
No, she didn't.
Even with all the problems she had at school and the media attention and the assaults on her character?
Well, if the girl was raped and she sought help through the police department and the justice system and it failed her, the regret is not hers for having come forward. The regret lies with the system because she was victimized and she felt like she needed help and she felt like she deserved justice. So in that regard, did she anticipate this situation? Absolutely not. Does she regret that it was handled the way it was? Absolutely, she regrets the way it was handled. But she does not regret having made the report, because I would encourage all rape victims to make a report and not to sulk away in silence because you may be facing an entire police department, which at the time she didn't realize.
Does this hinder, you think this hinders other people from coming forward if other victims hear about this case and how it was handled?
I fear it will. I hope it would not. But common sense dictates that what has happened in this case is going to affect other victims' reporting. Common sense would dictate that, ma'am.
You mentioned about the...
Sir, you've had your hand up for a while.
Thank you. I
Yes.
appreciate it. Last question from me. Up to this point in time, has Mr. Winston, in your opinion, gotten away with rape? Up to this point in time, has Mr. Winston gotten away with rape?
I'm not going to comment on that, sir, because I'm not interested in getting sued. Okay? He hasn't been charged. He hasn't been investigated. So,
But you're
does
still
my...
alleging that he did rape your client.
My client is alleging still that he raped her on December 12th, 2012. Absolutely.
Last question from me.
Let me see. Anybody else? Yes, sir.
Okay, I did want to ask, you mentioned about the very flawed investigation in your view from TPD. You said that you used to work as an assistant state attorney. Given what Mr. Meggs was presented by the Tallahassee Police Department, do you think could he prosecute this case given the evidence he was given by the Tallahassee Police Department?
I believe he didn't do enough to make that determination. In other words, if he had analyzed and tracked the chain of evidence as to the blood and the urine, if he had tested the blood for drugs, if he had obtained phone records, he didn't do enough to make a filing decision. So, based on what he had, isn't the issue. The issue is what was not done. He basically just went over this again. I mean, I go through here, and there are some, I don't know if they're, I guess they're text messages. And when I go through here, there are text messages, and I'm not sure who asterisked them. But anywhere in here where there's a text message where the victim might have made a simple reference to a friend like, oh, I passed a test in 13 minutes and was drunk at the time, asterisk. Something about boys, asterisk. All these asterisks on her text messages that are clearly trying to show that she's some drunken, promiscuous girl, which it doesn't show. If you look at it, you can clearly see she's a nice girl. She's a regular college student. But that's what's being asterisked in here. Now, if I don't know if the state asterisked those or if Angulo or TPD asterisked those. But if I'm Angulo, I'm looking, I mean, if I'm Meg's, I'm looking at this packet that I received, and I see a lot wrong with it. And so I would have taken a totally different tact than Meg's did. And in fact, I met with Meg's and said, here's my concerns, and laid it all out. We met for 2 hours and 13 minutes, and I addressed all the evidentiary issues of the case, including the second DNA and what is a motion in limine, which would completely make that inadmissible, and et cetera, et cetera, et cetera. So I tried to say, here's what I think is important in this case, because I've met with the victim, of course. And I hadn't even reviewed the police report yet, and I was suggesting certain actions needed to be taken for a proper investigation without even having looked at the police report. In fact, when I met with Mr. Meggs on that day, I asked for a copy of the victim's written statement, and the investigator for Mr. Meggs' office said, we can't find it. It's MIA. I said, are you telling me the victim's statement in a police investigation of a rape is MIA? Well, yeah, we'll try to find that for you and get that to you. I never received that statement from the state attorney's office until I received the packet. So he could have done a lot more than he did. So there's a premise problem in your question, which is, could he have charged based on what he had? He should have done a lot more. Yes, there was a gentleman over here. You asked a question.
I'm John Cypus, and I do news for AM 820 down in Tampa Bay. All of us have been around this business for a very long time, and we've all witnessed at one time or another the difference cases of the law versus the politics of law. In your summary of this, would you say that we have an awful lot of at least circumstantial evidence that we're looking here at the politics of law getting in the way of the investigation?
Now I'll say, after looking at all this, it may be the politics of football. Somebody asked me earlier about football. I don't know so much the politics of law as it is the politics of football as regards Tallahassee PD. I don't know. That's what it looks like to me, because the victim identified on the very first day, with her scattered, fragmented memory, that there was a guy named Chris. And the guy named Chris was a freshman starter on the football team. He's the guy who grabbed her near the restroom and started talking to her before she took that shot. His name was Chris. In her report, the victim's report, she stated a couple of girls came over and said, that's Chris, he's a freshman starter, the only freshman starter on the football team. She remembered that. That was before she took the shot. So conveyed that to Angulo. That guy could have been found day one. How many freshman starters named Chris are there on the football team? Why did Angulo not go find the guy who she gave her phone number to? Because recall, she received a text message saying, come outside. She only gave her phone number to one person, the guy named Chris, the freshman starter at the football team. It's really not rocket science for Mr. Angulo to figure out who Chris is on December 7th or on December 8th and go interview Chris, who turns out to be Chris Casher, and get his statement before, 10 months, 11 months elapse, before Attorney Jansen has an opportunity to interview him. He would have then been connected to Ronald Darby through his interview with Mr. Casher. So what was Angulo notified at the very beginning? That she didn't believe Mr. Casher was even in the cab. Her head was so screwed up. She said, I don't think the guy Chris was in the cab, but I can't be sure. But that's the guy I gave my phone number to. It's really basic investigatorial procedure to go find the guy who she gave the phone number to, check his phone out, see who he talked to. Then he would have found out about Darby, and he could have interviewed Darby before Jansen got to him. So the statements by Casher and Darby taken 10 months after, somebody asked me earlier whether or not they can be relied upon, or whether or not a filing decision could be made in reliance upon those statements, is absurd. It's absurd. Those statements are tainted. It very well would likely be tainted. Yes, sir.
Joey Johnson from the Tampa Tribune, you mentioned that don't think Willie Meggs did enough in this investigation, because if Winston would have been charged last week, he would have been ineligible to play in the game that led to their national championship. So do you feel that the football aspect led to the closure of the investigation when there was still something to investigate?
I don't know about that, sir. I don't know about that. I don't know why Mr. Meggs did not get a search warrant for those phone records and scrutinize those. I do know that the day before he made his press announcement, he had a meeting with Mr. Jansen, who apparently was Winston's lawyer, who apparently was expressing concerns about how long Mr. Meggs was taking. Mr. Meggs had 13 days. He gave himself 13 days to conduct an investigation. Now, you must ask yourself, because I'm not going to make a conclusion on this, but you must ask yourself, if you have an investigation such as the one Angulo did, let me just take a brief moment, because this is pertinent to Meggs' decision. When Mr. Meggs received the report from Mr. Angulo, he had to have noted, and he and I did discuss this, that Angulo failed to go to the club in question and obtain the security surveillance. He knew that Angulo never got a search warrant for Winston's apartment. In other words, when the victim identified Winston on January 11th, when she called Angulo and identified the victim on January 11th, he needed to get a search warrant for the premises where this rape took place. He didn't go and get pictures of the apartment. He didn't get a search warrant to see if there were fluids. If you recall, this occurred based on the police report and the victim's statements. This rape occurred not only on the bed, but also on the bathroom floor. Who has consensual sex bent over on the bathroom floor? That's really not a hard concept to argue to a jury if you're going to prosecute this case. When Meggs noted that Angulo failed to get any search warrants for Winston's apartment, that he failed to get any search warrants for Casher's phone, Darby's phone, that he didn't take basic interviews, that certainly should have alerted him that he needed to do everything possible in this case to obtain justice, regardless of how long it would take, and irrespective of a football schedule. Now, when Meggs said in his press conference, or Mr. Meggs said in his press conference, that he does not conduct his investigations around a football schedule, but he conducted this investigation in 13 days, released it right before the Heisman Trophy. I mean, you have to just put the facts together and draw your own conclusions. I'm not going to stand here and accuse Mr. Meggs of purposely doing that and no charging. I'm not going to do that. But it's clear and evident that a lot more work needed to be done, a lot more than 13 days needed to be utilized for him to get all the necessary evidence in this case, and that was not done. Why it was not done, I don't know if it has anything to do with football or just, I don't even, the other thing would be incompetence. I don't think Mr. Meggs is incompetent. I mean, he's been doing the job for 40 years. I don't really know what his reasons were.
Do you have any idea who tipped off the news media about this case, ma'am?
No, sir. Do I have any other questions? Yes, sir.
Eric Adelson, Yahoo Sports. You said there were probable causes there. At what point was there to you in the investigation? At what point did you see there is probable cause?
While I'm not a law enforcement officer, my understanding of probable cause, I don't generally do I've never done a probable cause affidavit, frankly. I'm not a law enforcement officer. But my understanding of probable cause and how it works is, if an officer believes a crime was committed and has a suspect who's been identified, then you have probable cause. Certainly to seek a search warrant. You know, whether or not at that time you have probable cause to do an arrest warrant, I don't know. You might want to ask somebody who specializes in affidavits of probable cause. But if an officer believes a crime was committed and has an identified suspect, I believe at that time he has probable cause to obtain a search warrant to get the DNA from that suspect, and then upon getting a DNA match from that suspect to do, or even before that, I don't know, but to obtain a search warrant of the location of the crime, which would be Winston's apartment. So I believe he had probable cause to do that, certainly on the 11th of January when she identified Mr. Winston. He had not gotten search warrants of all her phone records at that time. What he had on January 11th was injuries, cry-out witnesses, an immediate report, a person who appears to have been drugged, intermittent memory, severe headache, didn't know what happened. You have all those elements, and a victim who by then had given 5 statements of a rape victim. By January 11th, he had 5 statements, all of which were consistent. That certainly should have prompted Angulo to at least believe a crime had been committed. A medical record that says a sexual assault occurred. I don't know that the hospital removed that material from the medical record. I seriously doubt it. We went down and got all the records from the hospital. And our records say sexual assault. So there's a record from the hospital that says sexual assault. So there's clearly, as of January 11th, an abundance of evidence to support that this young lady had been raped. So that's the first element of a probable cause affidavit. The second element is, do you have a subject who's been identified? When he was identified, probable cause existed. Then you conduct your investigation. Then you get your DNA. And then he would have matched the DNA. The state matched the DNA in what? 5 days, 7 days? They matched that DNA? Angulo could have gotten that DNA match in 5 to 7 days. He failed, not only failed, sir, he refused to submit to collect DNA from Mr. Winston after he was identified. Does that not speak for itself, sir? To your question earlier?
Yes.
Yes.
And a follow-up, what was your reaction, or what was your client's reaction to the press conference, next press conference, tone of it?
She cried. Any other questions?
Can you elaborate on that a little bit more?
I really can't.
Or did you call her to tell her? Did she call you to cry on the phone, or how did that unfold?
She watched that with her parents. I was picking out a casket for my mother. Any other questions?
What do you say to Detective, the Tallahassee detective who's watching this right now? What do you tell him and the Tallahassee Police Department?
What do I tell them? I don't tell them anything. It's not my job to tell anything to the Tallahassee Police Department. I'm here to express to the press that you have some missing records, specifically a search warrant, some medical records that are missing, and some questionable records that I can't account for missing information on those records. I'm here to express to the press that the family and the victim believe that this entire situation largely was an investigation of the victim, not the perpetrator. And we're also here to basically set the record straight as to any other questions the press might have. But I'm not here to tell the Tallahassee Police Department anything. Yes, sir.
She had no recollection of getting on the back of a motor scooter with a man and she says brutally attacked her. No recollection of that.
She doesn't recall getting on it. She recalls being on the back of it, and in fact, when the chief deputy state attorney, who was Georgia Kappelman, she interviewed the victim, and she specifically said, do you remember being on the back of the scooter? And she said yes. And she said, were you afraid you were going to fall off? And she said yes. In fact, because she didn't have her coordination at the time, she said her balance was off. She had to sit on the back of the scooter and actually lean against him so that she didn't fall off the scooter. Can you imagine? So she had to kind of just fall against him, otherwise, because she couldn't balance. So she did relate that information, that she was frightened during the time she was on the scooter. It was a very brief ride, but during that brief ride, she felt that she was going to fall off the scooter. But she does not recall getting on the scooter. She recalls being kind of slumped against him on the scooter and trying not to fall off.
What I like Tomahawk Nation.
Who are you with, sir?
Tomahawk Nation.
Yes, sir.
Given the lack of time to discover evidence that you claim has now been lost, what would you expect the Attorney General to find if they do indeed look into this case?
That's a good question. I think it's incumbent upon, did you say the Attorney General?
Is that who you called upon to look into the case?
Yes. I think it's incumbent upon the Attorney General to look at this entire investigation and see how it was handled and see if there is a systemic problem in the Tallahassee Police Department having to do with how rape cases are handled, presumably if they involve football players. I don't know if they're handled all the time like this. I don't know that. Obviously, there's been a lot of focus on the fact that Mr. Winston's a football player. But I would ask the state attorney to look into that. I would also, the Attorney General, I would also like to know what the chain of evidence was, have investigations and depositions taken as to exactly how that evidence was handled, how it was stored, whether or not it became degraded during those 37 days. In fact, when the FDLE sent their report back in March on the blood analysis, it said, please keep these samples frozen. So I don't know, I'm not a scientist, but that suggests to me that it's very important that blood or urine perhaps be kept refrigerated so that whatever is in the sample not become degraded, whether or not the delays in getting this information prejudice the case to the degree that I suspect it did. I don't know. It just needs to be looked into. The chain of evidence.
Was degraded or handled properly?
Sir, I have suspicions after what I'm looking at here. I had suspicions earlier, but I have not had an opportunity or access to test that evidence myself, so I don't draw conclusions based on speculation. That would be imprudent. I'm just looking at the facts that I have in front of me, and the facts that I have in front of me, I've already addressed the concern that we have regarding those. And I think at this point we've answered enough questions. Thank you, ladies and gentlemen, for your time. And FYI, we do have a packet. I have some packets here that I would like to disseminate. I have for each, and oh, okay, don't take my stuff, please. All right, yes, these are just some hand per agency. We only have 40 of them, so if you cannot duplicate an agency, and we're going to send these out also via email. Thank you.
Thank you, ma'am.
Thank you. Thank you. I appreciate it, Chief.
Thank you very much.